Ron. We're going to now take a journey through the process of starting the lawsuit. We've already filed it. We've done our conflict checks. We've decided what the claims are going to be. Now we file it. Now, when I started out, to start a lawsuit, you had to give a paper copy of it to the clerk of the court, depending on the court where you're suing. And you could do that by sending it by courier, walking it into court yourself, which is something I actually used to like to do. In the Southern District of New York, even though everything was done according to electronic filing, the one thing you couldn't do electronically was what is called case originations, which means filing the case. You couldn't start a case sitting at your desk. Now you can. You can sue somebody at 11:59 at night and 59 seconds in order to beat a statute of limitations. I don't recommend that you cut it that close, but you could do that. Case originations are now done in every court where I practice, certainly all the federal courts, electronically. You do have to fill in some information. You have to pay a fee. The filing fee can be several $100s. I mean, that doesn't even come close to offsetting what it costs to manage your lawsuit in the judicial system. And they also want to de-incentivize people from truly frivolous filings. So that's non-refundable. You don't get that money back no matter what, whether you've gotten dismissed or whether you change your mind the next day. That money goes to the United States government. You file a case. The way it works now is that it is electronically generated. It gives you a docket number. Docket number always starts with the year in which the case was filed and then a serial number. It's assigned to a judge, a process that, depending on the court, can be immediate. It might not be. In New York, you don't get a judge. I've got cases in New York State Court, but most of my work is in the federal courts, and you do tend to get a judge almost immediately. So you find out who your judge is, and you're off to the races. You now have 20 days to file. Not 20 days. After you file the complaint, let me take a step back. After you file the complaint, you need to also file a summons, but it can be immediately after. You file in the federal system a request for a summons. You fill out what the information is that should be on the summons, which would be the caption of the case, the docket number, which you now have because it's been generated by the system, and the address of the defendant on whom the summons is going to be served. The clerk will then, after confirming that everything is on the proper, that you've met the appropriate technical specifications for filing a lawsuit in the electronic case filing system, generate a summons, which you print out, and then the printed summons and the complaint are served on the defendant. Each defendant gets a copy of the complaint. How do you serve it? Anyone can serve it. There are process servers who are experts in this. And sometimes being an expert doesn't mean anything at all. It means that you drive up to some office and make a delivery, get someone to sign for it if you can, or you go to the Secretary of State where they know you and you know them. Here are today's lawsuits against corporations in this state. You have 120 days after filing the complaint to serve the summons and complaint. That is a deadline that you can get excused in some cases. Some judges are not that particular about it. You pretty much need to get it done in a couple of months. Why so much time? Sometimes you want to file a complaint and you don't necessarily want the lawsuit to begin. Let's say you are anticipating that the other side is going to sue you and that maybe they're going to sue you in a faraway state and that they don't necessarily have a contractual right to do that. But if they sue you first, there is a rule in most courts called the first to file rule. If someone in New Mexico files a case against someone in New Jersey, let's say it's just a contract dispute between two parties, and there is no contractual term that specifies the form in which the litigation, any dispute, would be litigated. The party that files first gets to choose the forum. So that could be of great convenience to you. It could save you a lot of money and maybe impose cost and inconvenience on the other side. But on the other hand, I want to sue first. Yeah, I want to reserve my chosen forum, but I'm not really ready to mix it up yet. So you can file the lawsuit, and there's a very good chance that the other side won't know about it. Now, there are some companies that have services that monitor court filings all over the country for them and then report on when there is a lawsuit filed against them. But most businesses and most people don't have such a service. And if you're in a district where the news media don't watch so closely about what gets filed, or there's no particular reason that your case would be considered newsworthy, there's a very good chance that the lawsuit that is filed won't be reported unless and until, or won't come to the attention of the defendant unless and until you serve the lawsuit with the summons and complaint. So you can continue negotiating, you can continue staring contests, you can continue threatening each other, whatever the case may be. You don't have to show your hand necessarily in terms of serving the defendant until a few months have gone by. Then there does come a point where the courts don't want you filing cases and then walking away from them. After days, the case may be dismissed for lack of prosecution. You might want to make a motion to the court explaining why you've been unable to serve. Now, what if you can't find the person that you want to serve? Well, let's say you're suing somebody who's anonymous on the internet, or somebody who has moved or is trying to evade being served. The only way, as a general rule, that you can't serve someone is by mail. And even then, there are exceptions. You usually have to serve someone in person, or if it's a corporation, an officer, an agent, or the headquarters. If it's a person, you can serve them at home or at their place of business. As long as you can establish that that's really where they live or that's really where they work, you can file an affidavit of service and it will be upheld as good service, even if the person wasn't at home. So there isn't really a tremendous amount of benefit to hiding under the bed in your own house, pretending not to be home if a process server comes. All you have to do is get someone to come to the door and take it. There's even something called nail and mail. It's best known under New York state practice, where you nail the complaint or paste an envelope containing these papers to the door of the place you're serving, and then mail them a copy. And then you file an affidavit saying, here's what I did. It's not as solid proof of service as you might like, but it does technically suffice. And if ultimately you can prove that you served what you say you served, and you'll probably be okay. There's another expression that comes from New York practice, which is sewer service. Sewer service means that you claim to have nailed and mailed it, but you really just, your process server just dropped it in the sewer. He didn't care. He'll let you worry about it. You have to fight it out in court. There's a lot of historically funky stuff involving process servers, but in most civil cases, in most situations where businesses are legitimate, businesses know each other, it is kind of awkward to come into court or have a lawyer come into court and say, we're not agreeing that they served us properly, but we're here to make a motion to dismiss the case because it wasn't served properly. So sometimes the judge will just look at the lawyers and say, okay, but are you going to evade service? I mean, obviously you're aware of the lawsuit. You're not allowed to evade service. A number of years ago, Congress passed a law that said that if I file a lawsuit, I can send a letter to the defendant with a copy of the complaint and say, look, we just served you. In exchange for giving you an extension of the time to answer from 20 days to 60 days, will you accept process or service of process through the mail? In other words, by way of this letter. So in exchange for my not having to send a process server to you, you get an extension of 60 days. Keep in mind that usually that 20-day deadline is going to be extended either by consent. If you ask the judge for more time, you'll at least get a couple of weeks. But the rule basically says if you turn down that offer and then they have to serve you, the plaintiff has to serve you, they can ask the court to pay the costs of service because you're playing games. Now, I've been in cases sometimes where service was impossible. For example, we once had to serve a default judgment for a lot of money on a person who had moved from Russia and moved back to Russia. But they had left behind a house in their name. This is for a trademark counterfeiting case or copyright counterfeiting. We had a default judgment for a very large amount of money. Serving someone internationally is far beyond the scope of any video. It's an extremely complicated and time-consuming process. But we asked the judge for permission to make alternate service. We had emails that we knew had worked for the defendants in this case, and we asked for permission to make service by email and also by publication. In this case, publication meant our order was granted. We got somebody to translate our notice of service, naming the defendants in Pravda. That was an interesting adventure. And the court ultimately held the service was good. This is, again, sometimes the subject of game playing, but it's not really where judges want to spend time. If you are a real person and you have a real home or a real office, you're going to get served. And like Bob Dylan said, you got to serve somebody. That somebody is you if you're the defendant. So that's today's lesson.